Should we get started or wait a couple more?
Let's just wait for 1 or 2 more minutes. A couple people are trickling in, and then we'll get going.
Okay, I'll wait for your signal.
All right, Amy, I think we can go ahead. I'll take care of advancing your slides. So if you need me to jump forward and I don't, let me know.
Okay, sounds good. Well, welcome to our next episode in our fundamentals series. Today, we're going to be talking about telling your story, the private placement memorandum. We'll be reviewing the arts and crafts of drafting an effective PPM. I'm going to go to the next slide. We have to start off with our disclaimer that, of course, we're just providing general information, and this shouldn't be regarded as legal advice. And on the next slide, we have here information about CLE credits. If you need any information, here's contact information. And we'll also be asking 3 polling questions during our presentation that will pause for a moment for you to complete. My name is Amy Bowler, and I am a partner with Holland & Hart. I chair our securities group, and you'll also be hearing from Adam Cohen, Leah Newman, and Ryan Nichols as we go on through the presentation, and I will let each of them introduce themselves as they take the mic. So we'd start off with saying, what is a PPM? Most people think of it as a legal compliance document, and it is. This is a document where you are talking about what you're doing, who is doing it, and what are the risks associated with what you're doing in a nutshell. And we do this to comply with the securities disclosure requirements. But it's also used as a due diligence tool. We have most funds will experience institutional investors, family offices, those types of investors who use this as a critical means for conducting their due diligence. It is for a PPM that is done right. It is also a very helpful and effective investor communication tool. Everyone loves their decks, but the PPM gets into the nitty gritty and can be, as I said, if well done, can be a very effective way to communicate with your investors and potential investors. And finally, we'll talk more about the construction of risk factors, which are a very important part of the PPM. But well-done risk factors work as effectively a form of insurance. If you are crafting specific risk factors, identifying specific risks, and those risks come to fruition, the fact that you included them and you addressed them in the PPM before someone made their investment decision is very protective in the event that something should happen to the fund and you shouldn't do as well as you intend and you have any shareholder claims, investor claims. We can go to the next slide, Ryan. We now come to our first polling question. Have you ever participated in private offerings of securities where the issuer used a disclosure method other than a private placement memorandum? If you can take a moment, we'll give you a minute to answer the question, and then we will keep rolling. All right, we will continue on. Why is a PPM necessary in the first place? Well, in many cases, it's not. As a legal matter, really what triggers the legal requirement for you to include a PPM is if you have non-accredited investors in the mix. We usually recommend to all of our fund clients that they not include unaccredited investors, that they stick with the accredited investor group for liability purposes. And so the vast majority of folks that we work with, the PPM is not a specific requirement from a legal perspective. However, frequently you end up doing a PPM anyway, and you do that for a number of reasons. One is the first reason that I discussed about risk factors. This is a form of insurance. It reduces your exposure, reduces your potential liability. If you have a disclosure document that explains in great detail what you're doing, who you're doing this with, who's operating the fund, and what are the attendant risks. If you do that, it can be incredibly protective to you. And so many people do it simply to protect themselves. Also, whenever you are offering securities, no matter what exemption you're utilizing, you're still subject to the anti-fraud rules. These are general rules that prohibit the fraud in connection with the sale of securities. And a way you demonstrate that you haven't committed fraud is by careful and thorough disclosure. So it's a way to demonstrate that you haven't done anything wrong that would violate the anti-fraud requirements. More and more, what we're seeing is that family offices, institutional investors, and other large sophisticated investors actually have a requirement that one, that there be a PPM, and two, that the intermediary review the PPM. So it's a due diligence, check the box type of requirement. And so many funds are finding that even if they might otherwise not want to produce a PPM, they, for practical reasons, they're required to produce it. And also, just in general, outside of the specific requirement that institutions and family offices might have, many investors simply expect it. It's their expectation in this space that they will be provided with a disclosure document and thorough risk factors. And so if you don't have that, many sophisticated investors will, that's a red flag for them. And so it can be an issue. So in certain spaces, PPMs are not used, but in the fund space, what we find is there is an investor expectation, and sometimes there is an internal investor requirement to see a PPM. And so we find ourselves, even if we're not compelled by law to do one, that we frequently are preparing PPMs in the fund space.
Amy, one other thing, if you don't mind, that I'd like to kind of add from a practical consideration perspective is in the U.S., this is a disclosure document. It's not a binding contract. To the extent you're making investments abroad, just be aware that some non-U.S. jurisdictions include the PPM as part of the contractual arrangement. And as a result, you would want to review that sort of with the same eye as you review a limited partnership agreement for a domestic U.S. entity. So just keep in mind that those terms are more contractualized, whereas in the U.S. it's more a matter of disclosure.
And we now have our second polling question. Have you ever prepared a private placement memorandum?
Thanks, Amy. I will take over from here unless you have any last thoughts.
one last thought before we transition is that one of the reasons that you might use a PPM, what we just mentioned, is as an investor communication tool. And to the extent that you're using it as a investor communication tool, and you include what would be called marketing or advertising material in your PPM, which sometimes does occur. Just be aware that there are new marketing rules from the SEC. Those will be in full force and effect in November. And prior to their effectiveness, we are going to be doing another program devoted to talking about those new rules, where it's too much for it to cover all in one session in this session. But I just wanted to flag that if you include marketing or advertising types of disclosures in your PPM, you would want to make sure that those comply with the new marketing rules from the SEC.
Thanks, Amy. I'm Ryan Nichols. I am of counsel in Holland & Hart's corporate group. I focus on securities and corporate aspects of fund formation, as well as institutional fund investments. So I'm going to kick off the second part of our discussion, which is focusing on the structure of the PPM, the principles surrounding the private placement memorandum, and then sort of what is the expected content. And so I'll address some of that, and then Leah and Adam will also handle some of that on the back end. So first, we need to talk a little bit about, what is the standard? As Amy talked about, there is no necessarily prescribed form, and there's no specific disclosure requirement in most instances in regards to these private offerings. So we have to really look at the standards from a principle perspective. And the PPM needs to provide, as you see, we say, truth, the whole truth, and nothing but the truth. And the PPM needs to provide investors with complete and accurate information of and disclosure on all material information regarding the offering, regarding the issuer, who I'll also refer to as the partnership, which is common in the fund context, management, business and operations, and risks. So materiality itself, there is no bright line test, and it is a fact-specific assessment depending largely on a mix of the information that's available. When you're assessing materiality, what is important to an investor and what should go in the PPM, you want to be conservative. Said differently, you want to be over-inclusive. So for example, if in a meaningful way, but if you think an investor might care and you're not sure, you should probably assume that they do. Any finder of fact, if there's a dispute in the future, obviously has the benefit of hindsight. So keep that in mind as you're preparing your disclosure. This is not just a business plan. As a starting point, a lot of times we receive a deck or a business plan or some other marketing materials. And while that's an important component of a PPM and a good starting point from a drafting perspective for our business description, it's not sufficient to satisfy all the standards of information and disclosure that should be in the PPM. So the PPM, further to this point, serves multiple purposes. One is as we said, it provides information about the issuer, necessary disclosure to avoid anti-fraud, tripping up anti-fraud rules, reduces the risks related to fiduciary duties under the Advisors Act, which I'll talk about in a little bit. But also, it is a principal marketing document for the offering. And as Amy said before, the Advisors Act has new rules in place, and they're coming out. They're in effect starting November 4th, and we'll be doing a presentation on that. But because this is a marketing document, you need to keep those rules in mind as well. So if there is no correct approach, what is your starting point? Well, sometimes, as Amy said, there will be prescribed disclosure required. If you are offering to non-accredited investors, there are certain disclosure obligations, including with regard to financials under Regulation D. But other than that, it's, as I said, it's largely principles based, and it's how do you avoid liability, and what do your investors expect to see? Now, PPMs for significant securities offerings, whether it's from an operating company doing a private placement, a large fund, your sophisticated investors expect to see a form of private placement memorandum that includes a lot of the same components. Now, what we've done in this presentation, we've tried to track these components, and you'll see kind of, we'll put greater emphasis on the ones that probably need a little bit more of your time while drafting. Generally, think about providing, from a securities perspective, think about providing potential investors with the kind of information that would be disclosed if this was a registered offering, although perhaps on a lesser scale. And to this point, the SEC, whether in their rulemakings or interpretive materials, has gone a long way to discuss what is important. In the 33 Act and the 34 Act context, has gone a long way to disclose what might be material to investors. And that is what is a significant component of the disclosures required for publicly reporting companies. So that's a good starting point. And if you're looking at where to go with a PPM, maybe start with Form S-1 registration statement, Form 1A for Reg A offerings. That's kind of a good starting point to see what the SEC and investors have deemed to be material in other contexts. Another practical consideration for the PPM on the sponsor side is it's very time intensive, and not only time intensive for the attorneys, but for the business parties as well, as I'll mention in the discussions of not only the management team, but the business itself and the investment strategy. A lot of sponsor side time is required to put this initial disclosure together. So make sure that in addition to coming up with the terms and the economics that are important to you and your investors, you're giving yourself and your advisors ample time to get a PPM in place. So as I said, the next few slides are going to talk about a number of disclosure topics. Some will essentially gloss over, others will dive into in great detail. But it's important to note that just because we sort of skip it, don't address it, or address it lightly, that doesn't mean the importance of providing important material information in a factual manner is not also important. To that point, the first thing is the cover page. And the point I'll make here for this generally non-substantive part of the PPM is, which includes basic information about the offering, is to the extent you are, which is generally the situation, trying to take advantage of a private placement without any general solicitation, consider either numbering your PPM or circulating it via a data room that automatically includes watermarks. This way you can kind of keep track of who sent and who received for the purpose of evidencing the fact that there was no general solicitation, which is a prerequisite to relying on private placement exemption. You'll probably, for those of you who have seen a PPM, you'll know that at the very beginning, there's often pages of bold or all caps language, which some people might call boilerplate. These legends are actually pretty important language from the fund perspective. It's self-serving, it's exculpatory language that provides various degrees of effectiveness in protecting the issuer. Now, I'm not going to go through the meanings of all these legends, but I do just kind of want to tick through what you might see. You might see legends stating that the offering is in jurisdictions where the offering may only be legally made, and it may only be made to persons who are actually meeting the suitability standards. There's legends saying that it may not be reproduced, copied, or shared, that no person is authorized to give information other than what is contained in the PPM. And this is in order to make sure that all investors have the same universe of information. Legends will say that the summaries contained in the PPMs are actually qualified by reference to the full document. So in the fund context, the agreement among the parties is in a very robust partnership or operating agreement. And while council is going to do its best to summarize all of the material points, we don't summarize, we don't just copy verbatim 50 to 150 pages of partnership agreement. So that's the purpose of that legend. Also, lawyers and accountants who are working for the manager, the advisor, the general partner, they're not representing the investors, and they don't provide advice on legal, tax, or accounting matters. So we need a legend to make that clear. There's also a cautionary disclosure regarding forward-looking statements, which mitigates the chance of incurring liability in connection with making projections, having statements about expectations, etc. So now to get into a little more of the substance. The description of the business, as I said before, is going to be a very robust discussion in any offering memorandum. And it's going to be initially prepared in most cases by the internal team, the sponsors team, the issuers team. And this section includes a description of the business of the issuer, as well as the investment opportunity that's being offered to investors. Now, in the context of investment funds, there's usually not going to be, unless it's an open-ended hedge fund, there's not going to be past operations to look at. And so what this is really going to look at is the investment strategy for the fund. It will often provide a discussion of prior affiliated funds advised by the sponsor. But if you are a sponsor and you are doing this, just be careful to make it clear, first of all, that any past performance isn't indicative of the future performance, but also make it clear that the investor isn't participating in those other funds. So it is clear what the investor is buying into. Now, I note here on the slide, we talked about how this section is used to help satisfy your fiduciary duties. So I'm going to take a brief detour to the Investment Advisors Act. So as a reminder for everyone, although exempt investment advisors are not subject to all provisions of the Advisors Act, they are subject to anti-fraud provisions and have fiduciary duties to their clients under the Advisors Act. And so the advisor's fiduciary duty is principles-based, and it's going to apply to the entire relationship. And so at all times, the advisor has to serve the best interests of its client. Essentially, you've also heard that the investment advisor cannot place its interests ahead of that of its client. Now, in a 2019 interpretive release, the SEC clarified, it was not a rulemaking, the SEC clarified a number of positions regarding the standard of conduct owed by an advisor to its client, and noted that an advisor's fiduciary duty, federal fiduciary duty, may not be waived. However, the duty will vary in scope depending on the relationship. And so what's really important about the business description, as I bring it back to the essence of what we're talking about, is the business discussion needs to talk about what is the scope of the advisory relationship. What is the investment strategy? What is the focus? And that business description is a way of tailoring and providing scope to the duty between an investment advisor and the fund. The next section regarding management, this again is more of this is another narrative disclosure prepared by the sponsor. Generally, who are the principals? Who are the key persons? We're going to talk a little bit about, you're going to need a biography for each, talk about their roles, their employment history, education, maybe some relevant skills. In some situations, you'll see that you need to disclose any sort of past improprieties or bad acts. This is in response to some of the requirements under Regulation D's bad act disqualification rules. If you do have a person who's tripping up these rules, just make sure you chat with your counsel, because it may not be sufficient to simply disclose them away. You may actually have a problem with having a good Reg D offering. So I don't want to get into that too much. That's a topic for another day. But just note if those improprieties are coming up, have a discussion about it. A little more on the PPM contents, conflicts of interest. This is another area that you're going to want to spend significant time with your counsel on, especially if you are a federally, or if you're an investment advisor covered under the Advisors Act. So you want to include a description of related party transactions and other conflicts of interest. Now, this is about as prescribed of a requirement as we actually do have for the PPM. And this gets to your fiduciary duty, specifically your duty of loyalty under the Advisors Act. Your duty of loyalty requires that, again, the advisor not subordinate its client's interests to its own. And in furtherance of this objective, an investment advisor must either eliminate or make full and fair disclosure of any conflicts of interest that might incline an investment advisor to render advice that is contrary or not necessarily in the best interest of its client. And so it's not sufficient. You'll see, whether it's risk factors and operating companies that just say there might be conflicts of interest. It's not sufficient to simply say a conflict of interest may exist if you know that it does. And you need to state those conflicts and those related party transactions with specificity. In addition, part of that is if you as a sponsor, an investment advisor, have multiple clients, you're going to need to state how you manage conflicts among those clients, how you are allocating investment opportunities, et cetera. From the investor side, if you're investing in a fund and you believe this disclosure is lacking, you have questions, the practical advice I have is go ask. You don't want to be in a situation where you are uncertain and you think you're going to have to rely on some sort of recourse under the Advisors Act or wait for an SEC action at a later date. Just go ask, because the sponsor should be providing this information. The next one that I'm going to talk about is use of proceeds. Now, this differs in the context of an investment fund from what you would see in sort of a traditional operating business PPM, whereas use of proceeds in a traditional operating business is a little more along the lines of these are each of the items, whether it's CapEx or something else that the funds are going to be used for. In the investment fund situation, it's expected and there's a presumption that the fund is going to be using expense proceeds for investments that are the basis of the fund's strategy disclosed in the business description. Instead, what there really needs to be is a discussion of the expenses of the fund. And so if you've been around any PPMs or any investment funds, as you've undoubtedly heard over the last several years, the disclosures of fees and expenses has been an extremely hot topic and the basement for enforcement actions by the SEC. And as a result, the expense disclosure in the PPMs and the expense provisions in the partnership agreements have snowballed into just pages of expense disclosure. And the reason for this is that the SEC Enforcement Division has said, look, private equity fund advisors have to ensure that the investors aren't paying more in fees or expenses than they bargained for, and that they have accurate information about fees and expenses. So when it comes to the use of proceeds, of course, you're going to be making investments, but the money that's not invested, that's going towards expenses, you need proper disclosure about what these expenses are. And you need to avoid situations where there's inadequate disclosure regarding operating partner expenses versus what's paid by the manager or one or another funds. And then you want to make sure that you have sufficient disclosure regarding treatment of back office expenses, compliance, legal, accounting fees, employment expenses, which should be allocated traditionally to the manager or the manager's funds. So the idea here is use of proceeds is is really going to come down to making sure you have full and fair disclosure about your expenses and what the partnership will be charged. Now, that said, a lot of this is going to be sort of in the future, hypotheticals, estimates. If you are paying any promoter, any placement agents, these are things that you may want to disclose with greater specificity, and also which you want to make sure are accurate, because they are in certain instances required to be disclosed on Form D. The last part of my section before I kick it off is you have basic offering terms, a summary of the offering, a description of the terms, which Leah is going to touch base on, the subscription amount, investor qualification standards, etc. And so I will, a number of those things kind of fall in Leah's court in the next slides. So I will kick it over to her as soon as I offer the next polling question, which is, which duty is an investment advisor complying with by eliminating or making full and fair disclosure of conflicts of interest in the private placement memorandum? Either the duty of care, the duty of loyalty, neither, or both. I'll give you a few seconds and then I'll kick it over to Leah.
Okay. Well, thanks, Ryan. As Ryan mentioned, my name's Leah Newman. I'm an associate in the corporate group. My practice primarily is focused on securities and capital markets transactions, and then institutional investor representation in the fund space. And so I'm going to start by doing a little bit of a deeper dive into the basic offering terms that Ryan was referencing on the previous slide. So potential investors need to know exactly what it is that they are investing in, which sounds obvious, but they need to know what types of securities are being offered. They need to know the price of those securities and the material terms. So the first point I go to is the fund PPM should state the minimum and maximum investment amounts that a investor can make in the fund. These set parameters on how much or how little investors can invest in the offering, and varies pretty dramatically depending on the size of the offering, the funding needs of the issuer, as well as the strategy and liquidity needs of the fund. These parameters can be set as either a dollar amount. You have to invest at least $25,000, you have to invest less than $1 million, or it can be set as a portion of the securities offered. You have to buy 10,000 membership interests, whatever that is. However, there should always be a minimum. If there's not a minimum, that should be included as a risk factor, as we'll get into here in a minute. Also, if the fund includes a min max in the PPM, if they elect down the road to change the size above the stated maximum or minimum, each of the investors who have already signed subscription agreements need to consent to that change in writing. Deemed consent is not sufficient in this situation. It's not acceptable for the issuer to send out a notice to existing investors stating that they're raising or lowering the minimum, and if they don't hear from you, we assume you consent. That's not sufficient in this situation, so make sure you're reaching out for written consent if you do change those amounts. As Ryan noted, the PPM should have a pretty robust description of the securities being offered. So this is the disclosure about the attributes of the actual debt or equity securities. Investors need to know details behind things like voting, information, liquidation, and preemptive rights, ownership interests that already exist, mandatory or optional capital call requirements, convertibility, call and put rights, whether the securities are collateralized in some manner, or other unique features of the securities. These attributes are going to be set forth in the governing documents of the fund. So a limited partnership agreement, maybe an operating agreement, that the PPM should reference, and the description in the PPM should be qualified by reference to those actual governing documents. This description is particularly important for quote unquote non-vanilla securities, such as limited partnership interest or LLC, membership interest in an LLC, just because the characteristics tend to be more varied and unique. It's not a plain vanilla security like common stock. So investors truly need to know what it is that they're purchasing. PPM should also include some kind of a statement on the valuation of the securities. For an existing company, this might take the form of a 409A valuation. In the fund context, it's a little bit different, but some savvy investors are going to require some kind of evaluation or an assessment of how the value was reached. So just be aware of that. Okay, risk factors. This is kind of the heart of a good PPM. So risk factors are effectively disclosures about the potential risks that investors need to consider when they're making an investment decision. As Amy noted, well-drafted risk factors act almost like an insurance policy. Risk factors that are included in a PPM with specificity that are narrowly tailored to the issuer and to the offering. If those risks actually come to fruition down the line, there's a very strong protection against potential investor liability for having included those risk factors. So this is an important part of any PPM. As I noted, risk factors need to be drafted with specificity, and they need to be narrowly tailored so that the risks are truly unique to the issuer and to the offering. A PPM should include both the text of the risk factors in its own standalone section, and it should also include a summary of the risk factors. This was a byproduct of SEC rules that were passed about 2 years ago that are intended to make risk factors a little less daunting to read. If you've ever looked at a registration statement, risk factors can go on for 100 pages. So the summary should give investors a pretty good high-level overview of what they're going to dig into once they start reading the actual risk factors. And they should really address many of the concerns investors might have when determining whether to make an investment decision. When drafting risk factors for inclusion in the PPM, counsel generally looks to the rules governing the inclusion of risk factors in SEC filings. And under SEC rules, risk factors need to include a discussion of the material factors that make an investment in the issuer or offering speculative or risky. As has been noted a couple times previously, a conservative approach should be taken. And when in doubt about the materiality of a risk, it's best to err on the side of including a risk factor on the point. And so while a broad approach should be taken when determining which risk factors to include in a PPM, all of the risk factors need to be specific and tailored to the issuer and the offering at hand. It's often a good starting place to look at precedent filings of public companies to get a sense of what other people in the industry or space are doing in terms of the content of their disclosure. But you can't just simply take risk factors from a host of different existing filings and drop it into a PPM. The risk factors need to be tailored to the company, to the business, to the risk, to the offering, to the management team. And the management or the sponsor, in the case of the fund, needs to be involved in that process. It tends to be kind of an iterative process where council comes up with some suggestions, management helps tweak those, and you go back and forth. But the point is, this is an area where sponsors can expect to spend a pretty considerable amount of time when drafting a good PPM. And I would just point to, there's a number of relatively recent SEC enforcement actions on the topic of risk factors. And the SEC has routinely stated that companies need to carefully consider whether prior disclosed risk factors have changed, if new risks have emerged, and if hypothetical risks have materialized. And the materials need to be updated to reflect those changes. And I believe, Adam, were you going to weigh in on tax risk factors?
I am. So just real quick, Adam Cohen, I'm a partner in our tax group. Before I speak to tax risk factors, though, I wanted to just interject a thought from the perspective of the recipient of these PPMs. When an investor, like one of our institutional investor clients, looks at a PPM, those risk factors can be daunting, as Leah mentioned, 100 pages sometimes. But those risk factors can be very helpful to identify where the real loss scenarios might be to the investment. And so while it's tempting to just glance over the risk factors, sometimes there can be some real good nuggets in there for the investor who may understand the space, but is investing in a fund because the manager knows it so much better. From a similar point, the tax aspects of the risk factors, there's usually a separate section of risk factors. Typically, people who do the investment side or that do the management side may not understand all the tax treatment or possible tax scenarios that may arise. And so the tax risk factors can serve a real purpose of identifying for both management and the investors where they need to be cautious. Sometimes they're really high level, just, the tax system's complex, go talk to counsel. But sometimes they can be very specific about the type of investment that's going to happen. There may be straddle rules, or there may be unrelated business tax aspects to an investment that may not be apparent from the overarching description of what the investment fund is going to be doing. So those risk factors can be helpful to all parties, which is why involvement of counsel is critical. Thanks, Leah. You're muted.
All right, thank you. A couple other items for inclusion in the PPM. PPMs can include projections and other forward-looking statements. You often see things like financial projections or forecasts, future business plans, that sort of thing. But if those are being included, there needs to be a legend stating that there are certain statements in the PPM that constitute forward-looking statements, a list of kind of indicative wording that might indicate that something is forward-looking, and then a broad statement that while forward-looking statements are based on reasonable assumptions, they're not a guarantee of future performance, and actual results might vary pretty dramatically from those statements. Ryan already touched on fees and commissions. I would just reiterate that whatever fees are included in the partnership agreement or other governing document. There needs to be no deviation from those fees in actuality. The SEC has brought a number of enforcement actions over the years against sponsors and managers on the grounds that the sponsor provided inadequate PPM disclosure or misappropriated assets of the issuer to pay such undisclosed fees. So the disclosure here needs to be very tight with whatever the fees actually are. And then the last point on this slide is the PPM should include a description of the material factors that are kind of unique to the issuer. And this is going to vary slightly on who the issuer is, but often it'll include a description of agreements that impact the rights of the securities being offered. So things like a stockholders agreement, things like the partnership agreement, and all of those should be described with reference to the actual agreement and qualified by reference to those actual agreements. Often you see a description of material agreements of the company. This might be things like land purchase agreements, debt financing agreements, licensing, major supplier or vendor agreements, whatever is material to the business of the company, whatever agreements are material. If the company is dependent on material IP or real property assets, you'll see descriptions of those in the PPM. And then if the company has been involved in material litigation or material litigation has been threatened against the company, there should be a description of those, especially as it relates to if there are any prior bad actor disqualifications against the management of the fund. Those should be clearly delineated. And the last one here is for companies or funds that are operating in highly regulated industries, so healthcare, energy production, that sort of thing. There should be a robust description of the regulatory scheme and the regulatory bodies with oversight. The goal, again, is really to provide disclosure regarding any information that would be material to the investment decision. So this needs to, again, be well tailored.
So let me interject here about the tax considerations. And before I do, just to put in the fund context a little bit, the regulatory, every business and entity in at least the United States is subject to tax, but they also may be subject to the CFTC regulation. The FCC can sometimes regulate funds because of their attributed ownership in media companies. So those regulatory aspects of funds can be very important to consider. Because every fund has tax considerations, and you've heard a few people here talk about, well, you're trying to describe what's unique and what's material to an investor. There's often a debate about, do we include a tax description at all? If every fund is going to have to file a tax return, if every partner in that fund is going to have to pay tax on their income, why is that unique? And in a very simple investment, it may be that a tax description isn't needed, or that a very simple tax description can be used. But in a lot of situations, and again, because the fund is trying to be protective, there's an inclination to include a more robust tax consideration provision. If the fund is doing anything unique to they're not just buying and holding stocks long, say, there may be a need to discuss the tax impact of various aspects of the investment strategy itself. And so that combined with the complexity that tax law brings in the context of funds, which are almost always, at least for U.S. investors, partnerships, flow-through entities. There's often a need to have a fairly descriptive tax disclosure that will explain not just what's going on inside the fund with the investment strategy itself, but how does that then impact the investors as it flows out. When you have certain types of investors, you may structure your fund as a entity that's taxed as a corporation for U.S. tax purposes, in which case there will be very different tax considerations for the investor. And so you may have an offering where there's an onshore fund for U.S. investors and an offshore fund for non-U.S. investors. And while the PPM may overlap in a lot of ways for both of those two offerings, the tax considerations may need to be significantly different.
Thanks, Adam. The last thing we were going to leave you with is there are other investor-specific disclosures for certain types of businesses and certain types of investors. So if you are in this space, make sure that you chat with counsel about what needs to be added to address those risks. And I will hand it back to Amy to discuss supplementing and updating PPMs.
Sure, and this is sort of our wrap-up slide, so we are almost done here. There is no specific duty to update when you've done disclosure. So you've put your PPM together. There isn't a requirement to continue to update it as you go along into the future. However, while you have a live offering, it is always a good idea to supplement your PPM if there's something that changes, if there's a new development, or if the information changes. You want your disclosure to be accurate when someone is making an investment decision. And sometimes this can get a little tricky when you have a long period of time where you're conducting the offering. And you can end up in a place, and we've seen this happen with funds, where you have people sending subscription materials in, agreeing to be bound to the investment, but you haven't closed yet. And then there is an interim development that you need to supplement. And so in some cases, if there is something that materially changes the investment and you haven't closed yet, even though you have received subscription materials, you may supplement that, and you may even offer rescission rights in connection with that supplement, so that you have a clean slate for closing, so that everyone is investing with the most current information, and you have allowed people to exit if they want to, given the change that occurred between the time they sent the subscription and the time you closed. So you can have those types of issues, but in general, there is no duty to update. However, you want people to be investing when they're making their investing decision to be looking at current and accurate materials. And one of the things that people do sometimes, which is a very big mistake, is if someone comes along later outside of an offering and you say, and they want to come in, they want to invest, and you say, oh, here's our most recent PPM, use it, and everything is outdated in it, it's probably worse to give them that PPM than to give them nothing. So make sure that you don't use old PPMs, that you are giving people, if you're going to give something to someone in writing that goes along with their investment, make sure it's accurate when they're making their investment decision. But otherwise, in general, you don't have to perpetually update your disclosure. And so I don't think that we have much time for questions, but if there are any questions, we can answer them in the chat box.
And I would just thank you all for joining us, and for those who watch the recording, we appreciate you taking the time to learn more about PPMs and our fund group. We're all, as you can see, we're all able to take phone calls and emails, and we're happy to answer questions that way as well. So we've been doing these quarterly. We'll plan on doing another one next quarter, and we very much appreciate you all, and we'll be talking soon. Thank you.
Thank you.